morning, Council. My name's Octavia. I'll be your court reporter. I have
Morning.
the case style, and I have Ms. Floyd's email. Mr. Johnson, could you please chat me your email address?
All right.
And
Do you guys agree to? I'm sorry. Do you agree to split the cost of takedown?
I'm fine with that.
Okay.
That's fine.
Okay. Thank you.
Ms. Winfrey, I want to make sure you have the correct email address for me.
Okay. I'm ready.
That should be the one with Travelers.
Okay. And apparently Travelers does something different with their invoices. Do you have the direct information to send the invoice to Travelers?
Well, actually, any invoices can be sent to me and then I'll forward it to the proper party.
Okay. Thank you.
Thank you.
Morning, everyone.
Good morning, Judge.
Morning, Judge.
Judge Richardson.
Right, let's go ahead with our hearing. I have a motion to dismiss or the alternative for summary judgment filed by the defendant. I have read the briefs, which are mercifully and thankfully actually brief, which is a welcome change from what I mostly get, but I'm ready to hear what you'd like me additionally to consider about the case. And I guess we'll go ahead and start with you, Ms. Floyd.
Good morning.
Judge, if I could, my apologies, Ms. Floyd. But apparently they filed a response to my response. And for some reason, I couldn't open it. I'm not real sure what it says, and it wasn't mailed to me, or at least I haven't received it yet. So I'm still willing to go forward. I think our response to their summary judgment covers what we needed to cover. But I know they filed a response to my response, and I could not open it, Judge.
I know that they did file a response, and I had no issue in opening it. And it was filed back on April 30th. That was the last one I had. So yeah, we're prepared to go forward. So
All right, Judge.
Okay. Thank you, Judge, and glad to hear that you were pleased with our briefs. The gist of this is that my client, who has actually been named as a party, Mr. David Cohen, has been sued for an alleged dog attack that occurred when the dog was in the possession and control of his wife. There's no dispute that they were married at the time. In my statement of facts, I laid out pretty clearly, the dog was on a leash. Mr. Daniels saw the dog on a leash with Mrs. Cohen as she was walking down the sidewalk and entered their property. The dog was still on a leash. They went to the porch. The dog was still on a leash. This is testified to by the plaintiff. As she was about to go inside, as commonly most people do, she took the dog off the leash. And at that same time, I believe the plaintiff was entering the property. The actions of the dog, Autumn, unfortunately, the dog can't testify for itself, appeared judged to be protective in nature. When Mr. Daniels entered the property, as you can tell, he is in the course and scope of his employment right now with UPS, driving while on this conference. Please be safe while doing that. But one would think, Your Honor, that in the course and scope of his employment, he would have tons of experience and training when dealing with animals that he actually knows are present and are there. The dog growled at him. This is not a dog bite case, and I think it's important to make that distinction. And he began to back up and fell according to his own deposition testimony. Highlights, Judge, here, the dog did not leave the Cohen property, okay? This is not a dog that was roaming at liberty. It was on its property at all times on a leash until seconds before when they were about to go inside. The dog ran towards him, barked and growled, Your Honor, it's my position that does not qualify him as a dangerous dog and clearly does not prove that he was vicious for purposes of causing the damages that happened to Mr. Daniels. Now, it is unfortunate that he fell as a result of this, and nobody's disputing that he fell. But under the circumstances, Your Honor, I don't believe that my client, Mr. David Cohen, should be held liable. And it's strange enough, 3 years later, the wife has never been named as a party to this lawsuit, although Mr. Daniels testified that she had the dog. Clearly, the time has told to be named, for her to be named as a party. And quite honestly, Judge, if we're forced to go to trial, that's an empty seat I will gladly point to that's not present there. So we think under the circumstances, the plaintiff does not carry his burden. There's been no violation, I believe, of the Fulton Ordinance. She maintained control of the dog. The dog did not leave the premises and was on a leash at all times until they got ready to go in the home. Second, there's been no evidence the dog was dangerous or vicious, Your Honor. Thus, we believe the case should be dismissed and the motion for summary judgment granted.
All right, thank you, Ms. Floyd. Mr. Johnson.
All right, Judge, and I want to thank you too for enjoying the fact that our briefs were brief. Those are the best kind as far as I'm concerned. But Your Honor, I'd asked the court to consider, even defendant's counsel states in her statement of theory of discovery, this lawsuit arises, this is a quote, this lawsuit arises from an incident between plaintiff and defendant's dog on April 19th, 2017. Even she states that the dog belongs to the defendant. Now, he may not have been present, but he does not have to be. All right, using that logic, Judge, his dog could kill someone while the wife has the dog, and he wouldn't be liable. You know, that is a question of material fact for the court to consider, especially a trial of fact and especially a jury.
Couldn't we have avoided this issue entirely if you just named him in the original, named the wife? Well, why wasn't she named?
Because no one was willing to give out her name. There were negotiations right up until the 2 years were up. I did not know what her name was. I knew what his name was because his name is the name on the house, and his name was on the package that was being delivered. So in an abundance of caution, I went ahead and found him. And also, he's the homeowner. He is the one who harbors the dog. All right. There was no way to get the name in time to file the lawsuit. And when I got the name, as she states, the time it told. But based on law, based on Fulton County ordinance, based on the OCGAs, Mr. Cohen, it's his dog. And I'll state here, Judge, Mr. Daniels was working as a delivery driver. He had a package for the defendant. It arrived at his home. He was told by the wife to come forward. She didn't restrain her dog. Okay, the court's going to be able to see from the video taken on this date that this is a big dog. All right, Mr. Daniels backs up as the dog is approaching. He doesn't know if the dog is vicious. Even counsel stated he's not on the leash when Mr. Daniels shows up. He sees a dog coming at him, a big dog. This is a Rottweiler, Judge. A big dog coming towards him. He backs up. Who wouldn't? Excuse me. After this dog leaps towards him, he backs up and he falls back and he shatters his wrist. He's been affected for the rest of his life. In the deposition itself, Mr. Parada, the attorney that took the deposition, asked Mr. Daniels to bend both wrists as far as he can. Trial fact is going to see that he is considerably limited in how far his wrist can move. That was because of this incident, Judge. He's been affected for the rest of his life. Under summary judgment, defendant needs to show there is no genuine issue of material fact, and that the undisputed facts demand judgment as a matter of law. Now, under OCGA 4821, it states that the dog owner is one who possesses, harbors, keeps, or has custody or control of a dog. Mr. Cohen had all of that. Plaintiff does not have to prove that the dog is vicious. Under OCGA 4821A6, it states one who owns a vicious dog and causes serious, can be considered to have a vicious dog that causes serious injury to a person resulting from reasonable attempts to escape from the dog attack. I think a jury should hear testimony as to whether or not it was reasonable, especially watching the video, whether it was reasonable for Mr. Daniels to be backing up or there's a Rottweiler running towards him.
Give me that citation again.
It is OCGA 4821A6, a small a.
Your Honor, I quote that exact statute in my reply memorandum.
And I quoted in mine, Judge.
However, the difference is,
I'll give you a chance to come back, Ms.
Go ahead.
I'll say I would ask you that I continue.
Go ahead.
All right. Again, Judge, Mr. Daniels didn't know how vicious this dog was. He sees a big dog not on a leash coming towards him, and reasonably he backs up.
Now I'm looking at
sorry.
in the reply brief, Ms. Floyd sets out some of 4821, and there's some bolded language in there. 4821B. It seemed like you left out the second part of it when you were giving your argument to me. The however, the acts of barking, growling, or showing of teeth by a dog shall not be sufficient to classify a dog as dangerous under this subparagraph.
Correct. But Judge, that's not what the video shows. The video shows him jumping on my client and my client falling back. That's more than what's listed there.
My understanding is from A, that it has to actually bite, not just jump and not just growl, but bite. What do you say to that?
Well, Judge, no. Well, my understanding is that as it states, one has to resulting from reasonable attempts to escape.
However, but you're leaving out the however. and dangerous has to cause a substantial puncture of a person's skin. I mean, that's what the statute says. Now then, if you're so he's either got to be dangerous or by puncturing a person's skin, or you've got to believe he's dangerous, but barking, growling, or showing teeth is not enough.
Well, Judge, a trier of fact can watch the video and hear testimony and determine whether or not they consider the dog vicious and dangerous. And I think that there's enough evidence here that should be heard by the jury to make that determination. They're going to have video proof, and they can decide for themselves. We're going to, of course, do request to charge and include that statute language, and they can make that determination. May I continue, Judge?
Yes, you may.
All right, thank you, Judge. Now, further, Fulton County Code of Ordinance, Article 6 states, one violates the leash law by allowing a dog to leave control of its owner. Fulton County Fulton County Services Ordinance Code Section 34-205 and left to roam freely.
I do apologize. Please hold on 2 seconds. I have a dog barking and I'm the only one here. I gotta put him down. I apologize.
That's all right.
Sometimes I wish dogs could talk.
You couldn't make this up. You know, I've got my kids have a Yorkie that doesn't bark no matter what happens. You know, I wish that dog would bark. Somebody could come in and be robbing the entire house. All she wants to do is come and lay at their feet. Total strangers.
I apologize, Mr. Johnson. Could you start from where you were reading? You looked down to read something.
Sure.
Thank you.
I'll back up to you ready? All right.
Yes.
Further, Fulton County Code of Ordinance, Article 6 states, one violates the leash law by allowing a dog to leave the control of its owner. Now, I understand that she took the leash off the dog just for a minute to unlock the door. She could have done that inside of the house. She does that outside of the house. You see it on the video, Judge. All right. You see her take it off. You see her turn her back to the dog. You see the dog see Mr. Daniels and run towards him. That's a violation of this ordinance because she's leaving him to roam freely. And there may be an argument as to whether or not that constitutes roaming freely, but that's an argument for the trier of fact. That's an argument for the jury.
Doesn't the ordinance say that the dog has to leave the premises?
And Judge, I apologize if it does. That's not what I saw.
I'm looking at ordinance section 34-205B1. The first sentence, dogs, it shall be unlawful for the owner, custodian, or harborer of any dog to allow or permit such dog to leave the premises of the owner or other person having custody of the dog, unless such dog is securely under leash.
And Judge, when I'm sorry to hear you, I couldn't hear the end of you, Judge.
I'm sorry?
I couldn't hear the end of what I can see your lips moving. I couldn't hear the end of it.
All right, so let me get closer. So it shall be unlawful for the owner, custodian, or harborer of any dog, so that encompasses Mr. Cohen, to allow or permit such dog to leave the premises of the owner.
And Judge, I'm sorry.
Go ahead.
I interrupt you, Judge. I'm sorry.
No, that's all right. That's the key part right there. To leave.
All right. Well, Judge, on the video, my client is stepping out of his truck. He's in the second driveway. There are two driveways connected. Okay. There's an argument that it left the premises because it jumps on him while he's standing in this other driveway. There's an argument as to whether or not that's leaving the premises.
I mean,
I'm sorry?
We're here on a motion for summary judgment. Is there proof, any proof in the record that he left the premises? This just seems to be supposition or speculation that he left the premises.
Judge, what it is it's video proof of where he is, and it allows the court to make that determination, or at least to try a fact to make that determination as to whether or not he left the premises.
But we can figure out, we could know before today what the boundaries of the premises are. You can get a plat. You could have a survey. I mean, there are means to discover the boundaries of the premises.
Well, Judge, you can see from the video he's in the other person's driveway. What's the question there? Are you following me, Judge? And the jury can see this.
I have not seen the video. I would like to see the video.
All right.
I have no objection to you seeing the video, Judge. We couldn't enter it in the record as evidence. How can we provide it to you? What's most convenient for you?
If you can't transmit it electronically, you can deliver a zip drive to Chambers.
All right, Judge.
That,
It may be
that's going to be a key point. If from the video there is a reasonable inference that can be made that they're not on the property, that may be persuasive to me.
All right. Can I continue, Judge?
Yes, sir.
All right. The court should be allowed just to hear and evaluate this evidence and be able to determine if Mr. Daniels is entitled to any compensation for his pain and suffering that he's going to suffer for the rest of his life. He's not going to be able to get similar work that he had. He's not going to be able to do that. He's limited physically forever now because of this incident. Everything that defendant's counsel has stated basically proves that this dog approached my client. Even if that comes down to an issue of viciousness, that does not come down to an issue of ownership. Does not come down to an issue of whether or not this dog was responsible for the injuries of my client. And a jury should be allowed to see this evidence and make that determination. That's fair, that's just. Again, I remind the court, summary judgment, it has to demand that the undisputed facts, that there be a judgment as a matter of law. There's enough here for this case to go forward. There's enough here to make a determination as to whether or not this dog harmed my client, and whether or not the defendant, the homeowner, is responsible for his injuries. We would ask that you consider that. Also, I would ask that you that the court consider bad faith in this matter. They've made zero acceptance of any offer as it relates to the injury to my client. Zero. They're not acting in good faith in terms of negotiating this matter. And the jury should be aware of that as well. Judge, now ask that this case go forward. I have nothing else, Judge.
All right. Ms. Floyd, you get the last word.
Thank you, Your Honor. And since we are in a virtual world, I think we both forgot, counsel and I forgot, that I can share my screen and show you the video right now.
All right, let's see the video.
If that would allow. Counsel has alleged that this was a big dog. I think the video will speak for itself. The video also shows that this fall occurred on my client's property in the driveway. So I'll let you look at the video. And hopefully I can share my screen successfully.
I need to give you permission to do that, so give me 1 second here.
Okay.
Okay, go ahead and give it a shot.
Let's see if I can do this successfully. Can you see the screen, Judge?
It says you've started. Yes, I see it.
You see it? Okay.
Yeah.
All right, I'm gonna hit play now. Hopefully this works.
There. He is off their premises, Judge.
He is,
He is in
the
the,
defendant, it looks like the plaintiff is off, may be off the premises, but the dog is on the grass in front of the premises.
Judge, the dog is on my client at that point. And if he falls, the jury should be allowed to see him falling off of the, away from the driveway and falling onto the
respectfully, Your Honor, I think it's my turn to reply. Plaintiff has made all kind of allegations here, but the video speaks for itself, Your Honor. The dog was still on my client's premises. The plaintiff clearly saw my client walking with the dog on a leash up till they got on the deck. There was nothing blocking Mr. Daniels' vision, and the dog was not a big, huge dog as he has alleged, but nonetheless, Your Honor, again, there's been no violation of this ordinance law. And we haven't talked about this, but my client, not my client, but the Mrs. Cohen was actually pregnant as she was walking the dog up to the deck. And so again, I think the dog's actions were just protective in nature. Mr. Daniels saw the dog, he clearly saw them. Plaintiff has argued my client could have unhooked the leash when they went inside. He could have waited until she walked inside with the dog likewise, Your Honor. So we're not here to discuss the plaintiff's injuries. What we're here to discuss is the fact of liability and if there's been any violation of law, and I submit that it hasn't, Your Honor.
And Judge, if I could just to respond to her, you can't hear the video, but you will have testimony as to the wife telling him to come forward. So if she tells him to, you see him her turn around and do this. If she's telling him, Judge, if I could.
Ms. Floyd, please don't interrupt.
All right, if she's telling him come forward, he's acting on her statement. Now, I understand that the dog may have been, I can't get into the mind of the dog. The dog may have been acting to protect her, but how does my client know? How does my client know anything more than the dog is running towards him and knocking him down? And Judge, all due respect, you say that the dog is on the grass. The dog is leaping towards my client. And I would ask that the jury be allowed to see that. That's fair, that's just. Going forward.
All right. I think I'm ready to rule. I think as to the argument that Mr. Cohen is not a proper party to the lawsuit, I deny the motion on that ground. I think the statute makes clear that you can harbor a dangerous dog, even if you're not the owner, simply by the dog being in custody on the property. But I do believe that in this case, the plaintiff has failed to prove that the dog was vicious or dangerous. There's no testimony, and the video shows that the dog didn't bite Mr. Daniels, and the video also shows that the dog was not off the property. And in order to prove the dog is dangerous by virtue of not being on a leash, the owner, custodian, or harborer has to allow the dog to leave the premises. And it's clear that the dog didn't leave the premises. So there's no proof that the dog is dangerous. And there's no proof that there was a violation. Now, maybe if the dog had chased him into the street or chased him into the driveway and that's where he fell, the dog left the premises, we might have a different issue. But that's not what the video shows, and that's not sufficient proof. I don't fault Mr. Daniels at all. I think Mr. Daniels is completely without fault in this incident. But the fact that he was without fault, and that he was exercising some care, some reasonable care and apprehension for his safety, does not translate into liability of the homeowner. So the motion is granted and the case is dismissed.
Thank you, Your Honor.
So Ms. Floyd, if you would submit a proposed order and judgment, please run it by Mr. Johnson beforehand, see if you can get at least his consent as to form, but not substance.
Gotcha.
And, Mr. Johnson, you and your client will have some options as to what
We
you
do.
But I think it's an interesting question of statutory construction. So, you may have an appeal. The Court of Appeals might see it differently, but
I think we do. You've already admitted that he is the owner of the dog. And with that, I think an appeal will go forward. But thank you, Judge.
All right.
Thank you for hearing us.
Thank you, Judge.
All right, take care.
Bye-bye.